Thank you very much, and thank you for sticking to your time. Mr. Roques.
Merci, Madame la Présidente.
Thank you very much, Madam Chair. With your agreement, if I may, I would first of all like to revisit a couple of issues that were raised by the petitioner. I'd like to shed some light, if I may, on the context, on the backdrop to the application of Directive 99/70 when it comes to contract agents and also agents of the European Union and civil servants, and of course the reference to the ruling, the fact that the Commission has systematically lost its case in judicial proceedings, the Strack ruling. Now that had to do with a completely different issue. It was the applicability of a directive to agents and civil servants of the European Union institutions. Why? Well, because, and in particular Directive 99/70, but directives in general, are not addressed to the institutions, or only in very limited cases are they addressed to the institutions. Now, the statutes talk about a mechanism. The only directives that will be directly applicable are directives that have an impact on health, a potential impact on health, and on the safety of agents working for the institutions. In Strack, the court ruled that, and this was then connected to other provisions in the statutes, the fact that we did not take into account the protection of leave, for instance, that this could have a negative impact on the health of these civil servants, and therefore there was an application. And we lost that case. But that's only with regard to the direct application of a directive to the agents, agents, working for the institutions. Now, if I may, I would like to recall an element in the petition which comes up time and time again. The petitioner is accusing the legislators of not having respected Directive 99/70 in their drafting, and also through the 6-year rule they are not respecting the directive. Now, even if it has no direct effect, because we're talking about a framework agreement which cannot be directly transposed to agents working for the institutions, nevertheless, we know that this particular provision is a direct application. We are absolutely in line with this. The legislator adopted this in 2004, then again in 2013, the statute, the 6-year limit. It is very much in compliance with the directive. Mutatis mutandis. I would refer you to Article 5 of the annex to this directive, which talks about the obligation to foresee a maximum term of employment when it comes to these fixed-term contracts, a maximum duration. And that's exactly what's happened here. The 2013 statute and the will of the legislator was very clear that time round as well. It was simply a translation of the will of the legislator. We had a 3-year maximum limit, and indeed it was felt that this did not meet the needs of the institutions, and that's why it was extended from 3 years to 6 years in order to be able to use the quality of the colleagues who we'd been able to recruit using that particular means. So from a legal point of view, we are very much in line with the directive. That's my first point. Second point, the court. The court has never challenged the statute, nor indeed has it challenged, when it comes to employment, the fact that we are relying on fixed-term contracts. Provided that that recourse is justified objectively, that is not called into question, and that is all that the statute does. There were 2 rulings over the last few years, one very recent one in fact, which dismissed the appeal submitted by U4U and US, so the trade unions, and the court, or the tribunal perhaps I should say, maintained the statutes as adopted in 2013. So much on the application of the statutes. And then other rulings, Kusuk, Maria Elena Lopez, also upheld this principle of a limited term and possibilities of employment, and using this system provided it is objectively justified. So the legislator has not gone wrong. There is no misstepping. The legislator is coherent when it comes to the statute, when it comes to the principles as well, which have been outlined and upheld time and time again. A final word, if I may, on the internal competitions, to complement what my colleague just said. Once again, the legislator wanted a limitation on access of contract agents to internal competitions, but it wasn't because they wanted to prevent colleagues from perhaps being successful at such competitions. There was protection sought by the legislator. What is that protection? It's against the risk of nepotism. It was against nepotism that this provision was thought up. Because if you have a selection of people who just happen to be closer to the institution, so if you don't have a competition, if you just happen to have people who are in Luxembourg, in Brussels, what have you, it was with a view to limiting that kind of effect.
Running out of time, a panel with 8 speakers was always going to be